Well, I hope your week has started well, and if it's Monday, it's time for you and your money. I'm Bryan. This evening we are focusing on estate planning. From time to time I receive calls from a spouse who's particularly concerned as the breadwinner spouse is too sick to deal with family financial affairs. Most of these calls are from women who do not have their own bank accounts, nor do they have the authority to transact and pay the monthly bills. A few examples of questions asked: my husband's had a stroke and I do have power of attorney. Am I able to transact on this account? My mom has an endowment policy. She's got dementia. Can I change the owner of the policy with the power of attorney? Joining me this evening is Tony Davey, Chartered Tax Advisor and Advocate at Tony Davey and Associates. And in the Zoom room from Mauritius in a tie is Gordon Stewart, Managing Director of Acura. For all of you who know Mauritius would know, and I always believe that people in Mauritius don't even know what a tie is. Gordon, good evening to you and good to see you looking so smart.
Hello, Bryan. How are you? Always great speaking to you. And hi, Tony. How are you keeping?
Yeah, nice to have you on the show, Tony.
Morning, Gordon.
There's a belief that a power of attorney will be sufficient for a family to operate the account when the breadwinner is unable to give instructions. Tony, please just give your views. What should families be considering? I mean, you hear this all the time. And what should families be doing? What should a husband and a wife be doing? What should they ensure that they have in place in the event of this type of thing happening?
Well, Bryan, a power of attorney is really granted in circumstances where you have some kind of temporary inability to act. So, for example, you're going in for an operation in a hospital, or you're going to be overseas for a couple of weeks or something like that. But it's implicit in South Africa that a power of attorney is only valid whilst the person who grants it, the grantor, has their mental faculties. So very technically, if you have somebody who in fact can't actually grasp what the transaction should be because of their physical or mental inability, then the power of attorney is actually invalid. So the solution is...
Before we come to the solution, Tony, so many organisations where you have a power of attorney don't even ask that question. You know, you transact this normally as if the person is around. People think that that's the solution, but obviously it's not the solution. And it's actually, are you actually acting?
Well, those acts are actually invalid. But yes, in practice, let's put it this way: people often get away with it. But if a person is mentally and or physically incapable of appreciating the nature of their actions, you can go to the High Court and apply for curatorship of that person. It's in terms of what's called a Rule 57, but a simpler process. But I emphasize that it's only in circumstances of mental incapacity, not physical. So if it's mental incapacity, under the Mental Health Act, you can actually go to the Master of the High Court and apply to become that person's administrator. All right? So only for mental. And it's a much simpler process because the Master of the High Court is an administrative arm of the Department of Justice. So you don't need to go to the High Court. So it's simpler and it's more cost effective.
But what about time? I mean, take the situation where this particular example I used, this husband had a stroke, so, and it came suddenly.
Well, that is a problem. Of course, bear in mind, some trust specialists would say, look, if you had your assets or a significant portion in a trust, then of course the trustees can act, notwithstanding your incapacity. So one must always bear in mind that's a third option.
They'd also want information. Maybe that's where Gordon comes in. Gordon, you've always mentioned the solution is the possibility of forming a trust. But you've also said there are costs involved in forming a trust. It takes time. And not all your assets should be in a trust. We're just talking about a simple situation where the breadwinner is incapacitated and has been in control. Gordon, your view of a trust?
Yeah, Brian, I mean, this is one of those age-old discussions that has been going around the circuit for years, because you're almost damned if you do and damned if you don't. Tony's covered the main options on how to deal with someone who does lack the mental ability or capacity to act. And as you've pointed out, one of the options is the establishment of a trust. But, you know, obviously, the trust has to be self-sustaining to the extent that there must be sufficient assets in the trust to cover the costs of the trust. But then again, if we're going to play devil's advocate on this one, which is the lesser of the two evils? The fact that you have to pay in a certain amount to a third-party trustee to administer the trust on an annual basis, or alternatively, sit in a position where you could be waiting for a long period of time to go through the curatorship, or alternatively to appoint an administrator. Bryan, maybe I can just speak from personal experience here. Unfortunately, my father had dementia. Lucky he had the foresight to create a family trust. He did put his assets into that trust. So therefore, when the dementia did get to the point where he was unable to look after himself, his planning had already been done. So I don't think that there's a right or wrong answer with this one. It's more a case of which is the lesser of the two evils.
Yeah, in your particular case, an example, I'm sorry to hear that about your father, but Gordon, I mean, that was planned. I'm talking about illness, sudden illness, heart attack, stroke, any of these things, what we call the dreaded diseases, critical illness. Tony, would you always suggest that a husband and a wife have separate accounts? I mean, there's got to be something done, because so often the breadwinner does all the administration and does all the paying of bills.
I agree with separate.
I mean, Bryan, you're right. I mean, you can take steps to try and make the other spouse more independent. Let them have their own bank account. Let them have their own investment accounts, etc. I do just need to throw in a caveat here. Remember that depending on how you're married, and unfortunately, I've seen this go wrong with a client or two in the past, where they actually made a donation across to the spouse, and then and they were married A and C with accrual, and unfortunately they ended up getting divorced. And because under those laws, that gift or donation between the spouses fell outside the accrual, the poor individual actually ended up losing quite significantly. So it's, again, there's just no clear right or wrong answer.
And also, forget spouses. What about where there's only one parent alive and children? We're not even talking about minor children. We talk about major children, and their bills have got to be paid, and the father's in control of everything. And you say power of attorney doesn't work, Tony, because it falls away under these circumstances. It's a problem. You must have come across this many times in your professional career.
Yes, no, it is a problem. As Gordon says, if you do have a trust, that definitely helps. And it doesn't have to be an all or nothing. You could just say, let's form a trust and put in, say, 1 million rand to cater for these sort of emergencies. But other than that, the Mental Health Act provisions for an administrator are certainly easier than going to the High Court.
And Tony, so let's say we form a trust, and there are 3 trustees, of which one is this disabled spouse.
Well, again, it depends upon.
Now you don't have 3; you only have 2 trustees.
Sure, but then you can make provision in the trust deed that in certain circumstances 2 will suffice.
Yeah.
Alternatively, you can appoint a 3rd trustee and try and get that through the master's office. But you must make provision. It depends on the wording of your deed.
Gordon,
Tony, I've got a question for Tony. Tony, I know the Law Society have been banging this drum for years, and I believe that there's a piece of legislation now waiting for, is it approval from Parliament? Has there been any further updates on that?
Gordon, are you referring to an enduring power of attorney?
Yes.
Yes, because, for example, like as I understand it in America, there is what's called an enduring power of attorney. So you grant the power of attorney whilst you are lucid, right, and capable, therefore, of making that decision. And then, notwithstanding a disability, being physical or mental, that power will actually endure. So we call it an enduring power. Gordon, I know there has been representation by the Law Society, but to my knowledge, it's still work in progress.
It has been around for a long time. I think, that this is such an important conversation because I'm sure all of us have been in discussions with clients who've actually been under the impression that if they give a power of attorney to someone in the event that they do lose their mental ability, that they're protected and that someone else can carry on looking after their financial affairs or other affairs. But unfortunately, that's not the case.
Yeah, not in South Africa anyway.
Yeah, I'm going to allow this conversation just to carry on a bit further because we're not talking about necessarily of people who are financially sound. We're talking about just general people who have, the bills are paid by the husband has the bank account, or the wife may have the bank account, but whatever the case may be, it's really problematical because we're not talking about curatorship. That's time consuming and costly. We're not talking about in the system. So, Tony, the best thing is just to make sure that there is an account set up for both spouses and there's money in those accounts.
Bryan, I agree with you.
Yeah,
I mean, that's a common sense
ban.
Gordon.
Yes, Gordon?
Yeah, just with regards to bank accounts, Bryan, just remember that in South Africa, so we're all used to offshore accounts. You can have multiple owners, and if one person passes away, the bank account still continues. South Africa doesn't have that. So when you've got an individual who's got the bank account, and then the wife may have her separate account, but it is linked to, let's say, the husband's account. When the husband passes away, that linked account also ceases and stops. So it's, again, just something to be very aware of, that if the spouse is going to open up an account, it needs to be a completely separate account that is not linked to the husband or wife's primary account.
Yeah, good point. I think, Bryan, yes, so separate accounts in the circumstances, and remember, there's no donations tax between spouses. So if you want to do, one spouse with the money can do ad hoc injections into the other spouse's account.
Well, look, I'm not going to get into it, but the last point I'd like to make, so much is on computers today. So the husband has the computer, the wife doesn't have access to the computer, all the accounts going to be paid come through your payment in your bank accounts and things like that directly. Quite a business, but I think it's important for people to understand. We're going to take a short break. When I come back, there are one or two questions I've still got for Tony and Gordon, and then I'll get on with the emails. Stay tuned. We'll be back shortly.